Anne is right behind me.
Ready to begin whenever you are.
We're ready to begin. Good evening and welcome to the March 6, 2025 meeting of the Public Safety and Sanitation Committee. My name is Stuart Desser and I'm chair of the committee. Tonight we're joined by District Manager Jesus Perez. This meeting is called to order at 18:35. It appears that we don't have any members on Zoom tonight, so we can skip that part. Members of the public who are attending virtually, you can raise any questions or comments that you have through the Q&A feature of Zoom. I should point out that although we're not legally required to take questions from the community, we do because we're all neighbors and we share the interests of the community. So if you are not a member of this board, but you want to participate, when it comes time, please raise your hand and we will recognize you when we can. Members of the public who are here in person, and there's none, hi, Anne. So we'll skip that. The taking of the minutes will be assigned to the absent committee member. We'll now take attendance by roll call. Jesus will call the roll.
Committee members, good evening. I will call your name. When your name is called, please say present. I will announce if there is quorum. Stuart Desser.
Present.
Thank you. Justin Goldberg.
Present.
Thank you. Gloria Page.
Present.
Thank you. Rupal Kakada.
Here.
Thank you. Stephen Perez.
Present.
Thank you. Michael N. Rose, excused. And Seligman.
Present.
Thank you. With 6 of 7 members present, you have quorum.
Thank you. The agenda for tonight's meeting was distributed ahead of time by the board office and is reflected on the screen before you. If there's no objections, we'll adopt the agenda. Members of the committee, if you object to adopting the agenda, please raise your hand. And seeing no objections, the agenda for tonight's meeting is adopted. The meetings from the December meeting are being reviewed. Once they're ready, they'll be distributed to the committee. Jesus, I think everyone on the committee knows the ground rules, so we're gonna skip forward for the sake of time, but everyone please keep in mind that only one person should see the time. And for the sake of maintaining order, I will recognize you tonight. So the first agenda item is a resolution opposing the recent apparently forthcoming policies of the Adams administration that allow ICE agents, Immigration and Customs Enforcement agents, into city facilities that include schools, shelters, hospitals, and jails without a warrant. Do community members have any sentiments on this?
I'm in support of it.
You're in support of?
No, as in like support of the resolution you wrote, not support of letting
Yeah.
ICE in those places. Yeah.
Okay,
Can I,
please,
I want to understand a little bit more about the resolution.
you want, I'm sorry?
Understand
you
a little
read
bit
it?
more. Yeah, but what's the law, like, what's your thought process behind it? Or what's the overall broader thought process?
Okay, so there's two rules. The first one, which is, has been implemented, says that, and a city worker who feels threatened in some way by a federal agent, by an ICE agent, can therefore let the, agent in without a warrant. And that worker is excused from from their obligation to keep the federal agent out. It would be kind of astonishing that a city worker should feel so threatened by a federal agent while doing the job that she should say, well, you can come in. So what this really does is it creates a system where people can follow their own political beliefs.
Yeah.
And if they feel that ICE agents should be let in, they can, and they don't, there's no repercussions for it.
Okay,
Or go ahead.
I was gonna say, I'm not okay with the language, that talks about prisons being included in there. I think that's too extreme. Like, it's one thing to be schools, but prisons, I think that I'm concerned about, I understand wanting to like be tolerant and empathetic, but there's also the reality of a situation like a prison where there could be violent offenders. And so I have a problem with that language being used specifically.
For the prisons, in other words.
Oh,
Please.
Schools, I feel differently about
There's a difference between prisons and jails. And Rikers, a lot of the people held there have not gone to trial, which is kind of relevant to our, our next topic. And so, you know, presumed innocent, right? So it just makes it really easy as a pretext to do deportations that, you know, maybe they should happen, like, whatever. I mean, that's a much bigger conversation. But if we're saying, in some ways, sadly, there is not that much difference between prisons and schools. So,
I'm just not okay with affirmatively saying prisons. It's one thing, like, I can understand.
well, but that's the only place that right now,
I'm still not
there,
okay with
and
that
it's
language.
not even prisons, it's specifically Rikers. And that's where pretrial prisoners are held.
I think that I would think about maybe a different resolution for that, but I don't like using the same language for, because I don't think they're synonymous. Like schools and prisons, you're talking about very different situations. I'm just not comfortable with it.
I mean, cops can literally just pull up to a corner, pick up anybody they think without any cause or without, like, or mildest of cause, jaywalking. And if that person doesn't have money for bail or doesn't have the resources, they can get sent to Rikers. That person shouldn't be like,
Yeah, sure.
it goes back to an
Well,
innocent until proven guilty part of it. Anybody can be sent there. It's not so.
But you need to think of it, or my opinion is, it's important to think of extreme cases on both sides. You could also have somebody who's sent and is awaiting trial who's a violent offender.
so if they
So-
have a previous history, like they are there because of, you know, like there is a proven case and there's something else going on. But the other thing is that the legislation says the like sanctuary state or city says, I don't know, I can't quote it, but it's, you know, if there is a warrant. So if they're coming in for a specific person, saying like, you know, we have a reason to support this because we think he's a threat to public safety, they can go in there, like what, and maybe that's something that we need to articulate better here, because like, and I'm okay with that too. Like if somebody, if like ICE has a reason, but not to just come in and basically do a sweep.
Yeah, I think there's like thinking of extreme cases. I think, again, like at a school being like, well, there could be like, that's just not reality, but like at a prison, I am concerned about, that's what I'm saying.
But I'm saying, like, if they have a warrant, they
Yeah.
can, they can still come in regardless.
If ICE has a warrant,
For a specific person,
For a
instead of
specific-
doing like just a blanket sweep of the entire Rikers Island.
okay, so if ICE has a warrant and there's a, you know, if ICE has a warrant and there is a violent criminal, then they can still.
Whether
like,
it's a violent criminal or not, if they have a warrant. Like that's, I mean, that's part of the sort of exception. I believe
And that's always,
think
just to
so.
be clear, that's always been allowed.
The
If
case.
you have a warrant, then the person at the gate may have to consult with a superior, but yes, if you have a warrant, you'll be allowed in.
And that's actually related to the other thing that you mentioned, which is that, you know, it's something that anybody has the right to say when they are, so to say, like, do you feel threatened by somebody like presenting a warrant? Like, that's what you're supposed to do. Present a warrant, right? So I'm sorry, Justin, I don't
No,
want to feel like I'm not listening.
no, I appreciate it. I just have a different point of view on it.
Not to digress, but just to share my own experience. I think everyone should go visit a prison. Because my first experience there was stunning. We went in there to do trauma work. But
In
I think it's
Rikers
yes, in
specifically?
Rikers.
Yeah,
And I think it's important to remember how people end up in these places. And the truth is, if there is a violent offender, he's still gonna be there and he's still gonna go to prison and they can still have access at some point, so. I think the system works. I just wanna bring a little humanity
Yeah.
to the topic. And the truth is, most people who end up in those places have off the charts, severe, incomprehensible childhood trauma and abuse. And it's stunning to go hear their stories, because that's what we do. And it changed me. Like, I was always afraid to go into prison. I never had been, and it was a totally life-altering experience, and I recommend it to everyone.
Okay,
That's
Steve,
it.
You,
Yes, I'm broadly in support of the spirit of the resolution, which is that upfront. I was doing a lot of reading about the details and the nuances of this today, and my understanding is that so after that memo was issued, and I think we need to be specific, because it just kind of says
Yeah.
January 16th, there was something, and I'm like, what was it? And I had to go searching for it. There was a memo, but after that memo, several agencies, like,
Yeah,
they actually issued their own guidance,
Right.
like the DOE,
It-
which actually said, no,
like push back.
you cannot
That's true, that's right.
let
Yeah.
any ice in. So I'm like, I don't think anyone's actually following that January 10th
Yeah.
guidance,
It's
because
like-
every agency that I've looked at has actually specified,
Oh.
no,
Hmm.
there's protocols, and you call us if anybody shows up asking for, and it doesn't absolve, nobody's absolved at this point of saying, oh, I felt threatened and I think I need to let somebody in. I just don't know that that's a real scenario.
Yeah.
Because
I-
of the way that it's been handled by the city agencies. So I think that kind of nuance is missing here, and then,
But, so.
and then there's aspects of legislation too that isn't quite captured here in terms of, it's like, and then some of the whereases where it's kind of saying like, oh, it's always been this. Actually, no, the first law was passed in 1998, and there was another law in 2014, there was another law expanding it in 2018, and then there was guidance put out. So like, I think there's some history there that would kind of like bolster some of the arguments that we're making. The last thing I will say is that I'm not quite comfortable with saying we want legislation at the end, I agree, we want the policies to stay where they are, but I'm not sure that we want to push for like a city law about this particular issue. I just don't know that we need to go that far, but that's kind of
No,
my
Sandy
overall
goes first.
comment.
I'm not a member of the committee, and was there pushback from this particular agency then regarding rifles? Was there something documented that they pushed back on this issue?
I was looking at other other city agencies who
So
had issued
DOC.
guidance, and I didn't find one on Department of Corrections, so I don't know
So
what,
Department of Corrections says not.
I'm not
Or
sure.
you
I
just
just
look,
don't
we
know.
don't know.
I did like a very quick search today
Yeah,
of this issue.
I just
But-
wonder if we shouldn't know that before.
Yeah, yeah.
Before full board.
I think that's a,
Just to specify it, sure.
yeah, because I also had a comment in my notes about, like, I think there was backtracking on that, like, I think that didn't, but I couldn't remember what it was, so thank you for doing that. I also had just kind of a general editorial, comment about in the third whereas. It's not just public safety and human decency, though it is certainly both of those, but it's just general public policy. Like, we want to send kids to school, like we want, and we talk about, I said, send kids to school, report crimes and offer witness testimony, and health, but we talk about the health, but we don't really, and we talk about the crimes, we talk about crimes not as a witness though, just as reporting. And we don't talk about school, like, which is the most like, duh, like, you don't want, like, that's, like, it's such an obvious public good, right? So if we can have kind of a couple words about that.
okay.
If I say that, are you gonna make me write them?
Well, I wasn't going to, but now that you've volunteered, I think that's a great idea. Thank you, Anne. And let's go back to, you would like to see the policy reversed, but you don't see a cause for legislation. Legislation prevents, not only can reverse the policy, but prevents it from being reinstated. Why do you not want legislation?
We've never had those laws in the city.
So why not though? Why shouldn't we?
I mean, it's not clear to me that you would need to go as far as a law. If the city has issued guide, I mean, we've been a sanctuary city for some time now. So it's not clear to me what problem we're fixing by asking the city council to pass another law.
Any other remarks? Justin, go ahead, I'm sorry.
Like, I usually try and have when I don't like something, I like to have well, how about this instead? Do you have how about this instead?
Well, I just would strike there at the whereas where let's return to the policies that were there and the guidance. But I think as a
And
whole,
just-
again, agencies are returning to that guidance.
Right, and
One,
just-
two, like the city, the mayor needs to rescind that.
But of course,
Which we've asked them.
you recognize that the
Yeah.
agencies do have to report to the mayor, and the mayor has the final word.
So is then that be it further resolved that calls on the mayor to embody the earlier policies and
Yeah,
legislation?
I think that's
Like,
already
just
in there,
literally.
right? That's the
No,
second to last word.
There's
just-
two therefores, right?
It's right, the first one is just a reversion to policy.
Reversion.
But if
Yeah.
if it's a more specific, call on the mayor.
I think that, well, that's
Does
the
that-
part that's missing from the beginning, which is it is the mayor's directive.
Right.
It just said
Oh.
administrative
So
policies.
do you think there should be,
I think we should add something.
do you think there should be a whereas saying
Just clarifying
the city's
Yeah,
mayoral
it just said, I think
administration?
administration, what did
It
that
just
say?
says
Yeah, it says,
administration.
city administration revised guidance encourages, like, what guidance?
But
That
like,
I
it's
was,
like
it's the mayor's
the.
memo, basically.
And, right, which
Yeah, I
is,
agree.
and we can
Makes sense.
cite, please.
So right now, it's the city agency, like the people in charge, right? The head of the agency who's saying that. Assuming that the city agency head agreed with everything he did, what then? Don't we need a law or a legislation that stops that from happening? We're in a position, or at this point at least, I don't know if you want to call it lucky enough or thankful enough to have agency heads who have agreed to reverse this
Yeah.
position. What if the agency heads didn't agree to it? Then what? Don't we need a protection in legislation that stops that from happening? What happens next time somebody comes in and they change the city agency head is different? What happens then?
Yeah.
What's
I
happening
mean,
with every single agency at a federal level right now? So don't we need the legislation to, in a long term, protect what we have to add that protection?
Justin, we'll circle back.
I was gonna say, there are just some whereas clauses that I'm uncomfortable with the framing of it.
Oh, then he should do the editing.
I'm not saying, I'm just bringing up my perspective. I think that there's a lot of phrasing in here that takes into account the potential impact on somebody who let's say is an undocumented immigrant or a child who could get adversely affected by this. But I also think that I think it's important to take into consideration also the potential impact of a violent criminal who is undocumented and really the potential negative impact on the community as well. I am uncomfortable with the phrasing of the first sentence, for example. Because that's framing is only taking in one perspective. And so some of the whereases I can agree with, but I'm uncomfortable with framing it in a way that doesn't take into account an issue, really two sides to an issue. I think it's more complicated than the way it's framed.
Steve, you look like you agree.
in some of the whereases, yes, I would say that, again, if we bring in the evidence the facts, the things that were cited, then we can
Uh-huh.
bolster a lot of what's here. Like I said, in the spirit of it, I'm in agreement, but it's the way that some of them are worded. They're not quite as strong as they could have been if they were grounded in an actual statistic, fact, law, policy, those kinds of things that are just would tighten
Can
it
I
up.
say one more thing? The situation, I mean, the reality is, I'm thinking of that woman who was burned to death on in Coney Island. What's her name? Deborah? Yeah. And if I passed her, like, if I voted yes on a resolution like this, I would feel like I didn't do my civic duty, because I would feel like it's one thing like, I understand protecting people who have undocumented status, but I also feel a responsibility to protect people like that too. And I feel like this doesn't take that, there, like, the reality of a criminal probably shouldn't be here into account. And that's just how I feel about it.
And
Okay, I will just say immigrants, like statistically are less likely to commit crimes than native born Americans,
Okay.
just saying. But, I also feel like I really, I really do hear like what your perspectives are really valuable on this. And to give kudos to Stu, like he did this, like we're not asking somebody to write a res over here because, Stu did the hard work, some of the hard work writing. Steve, if you and I want to work together on like the next version of this, does that work? Justin, I'm only cutting you out because he's already done so much homework. You're welcome to be
Okay.
involved, and we
I
can
mean,
include you.
We might just, I'm sharing my honest opinion about it, like my
No,
comments.
and I want
Yeah.
that to be reflected as well.
Okay.
I mean, I could just say I want all homeless people off the street, because right next to me where I live and walk every day, a woman was stabbed to death by a homeless person. I don't go there. I think our laws and our system works the way it is. If there's a warrant, if there's a trial, if someone's convicted or someone needs to be removed from the country, the system works. This is really more, I'm just gonna say it, a bullying pulpit. And it's for political
Yeah.
aggrandizement more than it's for humans or even Americans. I'm gonna say it on record right here, right now. That's my concern. So I think we need to be level-headed, and as everyone's trying to be, I see,
Yeah.
and understand that focusing too much like this loses a lot of the whole big picture. And our system generally does work. I mean, it works as good as any system can work. And I think the one thing that you mentioned, the first one, is a very scary thing, because if an immigrant is raped or brutally attacked and afraid to report that crime, that same crime can happen to the next person. So there's a ripple effect that can be extremely negative. So I think I understand all viewpoints, but I think we need to be careful about how we think about this. I mean, I think New York I know that the criminal justice system needs help. I get that. But there is a system and it works. And there's a system for how we determine who is guilty, who is innocent. And fair enough, we have a lot of innocent people in prison. I understand that. And also who needs to be removed and who doesn't. And when you blanket something, that is where I think a lot of mistakes can be made. And I just think we want to be careful about that. Just taking everything into account, I think we need to have a really full 100% view of the whole thing.
so we are agreed that Steve and Ann will be a committee.
With Justin,
With Justin
providing input
contributing,
as well.
and everyone can send their ideas to the committee, the subcommittee, sorry. And we'll come back to this next month.
Right.
And we're 2 minutes early, but it looks like we have all the participants who are supposed to be here for the second agenda item. Am I correct?
I believe so, at least from legal aid, yes.
Excellent. So,
thought that was gonna be the easy one.
I'm
Yeah.
here. I'm here. I'm a little time strained, everybody, but I appreciate having me nonetheless. And I apologize for the lack of formality where I am.
No worries.
we're pretty casual here. We're actually all in our underwear below the table.
Should we go ahead then, or do you wanna?
I will take a few minutes, with more words than I should to introduce the topic for anyone who's not familiar with it. There'll be some redundancy. You're both going to repeat some of what I said, and that's good because it helps people understand it. And to the extent that I say something that is wrong, you disagree with, this will be your opportunity. I'm going to raise the point. So, in criminal law, discovery is the process by which each side is handed in advance of a trial or plea bargaining evidence by the other side. Seeing the other side's evidence beforehand gives each side the opportunity to assess its reliability and deficiencies. Sometimes evidence held by the prosecutor actually vindicates the defendant or leads the defendant to exculpatory evidence. Other times, seeing the strength of the prosecutor's evidence makes it plain to the defendant that that fighting is futile, and so encourages the expediency of a plea bargain. Either way, the sooner the evidence can be and is shared, the better for justice. Defense attorneys tell us that before discovery law was amended reformed in 2020, prosecutors could and did lawfully conceal the evidence until the moment before trial or plea bargaining, thus blindfolding the defendant. Because defendants didn't know the strength or weakness of the state's evidence, even innocent people might take a plea deal rather than risk trial, especially if they couldn't make bail and they were held behind in Rikers. But with the 2020 reforms, prosecutors say the pendulum has swung to the other extreme. So if the state doesn't produce every last tidbit of evidence by strict early deadlines, and that includes evidence which the state says is irrelevant to the question of guilt, the case against even the most plainly culpable defendant will be dismissed. The cliche is that the defendant got off on a technicality. Now, cases might indeed be dismissed for reasons unrelated to guilt or innocence, but we do need to recognize that the rules of criminal procedure, and those, including those discussed tonight, are designed, at least in principle, to prevent innocent people from being wrongfully punished. These things called technicalities, when they work properly, help prevent innocent people from being wrongfully jailed, and they produce correct outcomes. So under the current law, the prosecutor has to turn over all evidence that is, quote, related to the case. Prosecutors say this creates an unnecessary burden on them without advancing the cause of justice. And so prosecutors say they should have to produce only relevant, not related, but relevant evidence. So a core question tonight is who decides what evidence is relevant? Defense attorneys say the prosecutor shouldn't be trusted to decide unilaterally what's relevant, and even evidence that might not be directly used at trial, if revealed, could lead the defendant to the evidence of innocence. But finally, I'm almost done, even that dispute might be rendered irrelevant if all the related evidence were easily aggregated. The problem is it takes a long time and effort to collect and prepare all related evidence within the statutory 65 days or 50 days if somebody's in behind bars. Police department systems are not that efficient. Prosecutors don't have insight into those systems. And once they finally do get the evidence, they might still have to take time to redact it before sharing it with the defense. So the system could be made, or I should say, if the system could be made more efficient, the whole of this controversy goes away. And with that, we're going to start with Andy, and I'm hoping I'm pronouncing your name right, Warshore or Warshore. Am I close?
This one, just like the two words, Warschauer. Ellis Island did a thing to Warsaw when we got here, so you know.
Warschauer, and he is the deputy chief of the trial division at the Manhattan District Attorney's Office, and he is, of course, in favor of amending the current law. So it is up to you to speak now.
Sure, and I am not in my kind of home Zoom setup, so if there are audio problems or video problems, please give me a wave, let me know. I'm kind of on the road here. I think I'd start off by saying the arguments that have been made against the law as it stood pre-2019 are all correct, and I am very glad I have not been brought here to defend the discovery laws as they used to be before reform. They were indefensible, I practiced under them, they depended very much on the good faith of individual prosecutors, I like to think that I was an open book as much as I could be, but we were not ordered to be, and it was not enforceable against us. So, insofar as what is being told to you is there's a desire to return to the old laws, that's not true, and it should not be true because they were not well constructed and, quite frankly, allowed for a lot of really abusive practices and bad outcomes. So thankfully, I'm not here before you to defend that. What I'm here before you to defend are changes to the language of a law that would be the same structurally after amended. And I want to start off by saying, the hard part about arguing against this is people say, the defendants in a case should have the evidence against them before they make decisions. And that seems very sensible. The problem is the phrase "the evidence" is doing a lot of work there. When you think about what the evidence in the case is, you think about video of the crime, statements of witnesses, police reports, body-worn camera, things that show guilt or innocence. And that is also relatively easy to obtain, and we'd have to obtain it under the governor's proposal. The stuff that's confounding us and is really tripping us up are administrative documents that were never put in a case file in the first place, or were developed for another purpose. One great example is we have to turn over to the defense evidence that, can show that any of our witnesses have, lower credibility. They might not have told the truth in the past. The way that's been interpreted is we need to produce the personnel file for every police officer who's interacted with a case. Okay, we can get to kind of the record of their sanctions. What have they been disciplined for? Did they access a computer for a non-police purpose? Did they fail to clean the backseat of a car? Were they dressed incorrectly? We can produce that. But beyond that, because this is a law that regards documents, not information, we've got to go dig up audio transcripts of interviews from someone who was disciplined in 2012, interview notes from someone who was disciplined in 2014. These are not the evidence in a case against a criminal defendant. And to say the problem is inefficiency in us accessing some kind of imaginary folder in which all of quote unquote the evidence exists, there is no folder like that. And I'd argue, the police credibility information is actually meaningful. There's a lot of stuff we get cases dismissed over that is absolute administrative nonsense. We have these things called pre-arraignment reports. There might be a field in there where someone could make a note, they never do. And it documents when you arrived at the courthouse and your kind of movements through the courthouse. There are property clerk chain of custody forms that show where evidence went within the property clerk's office. None of these are really case documents. They are things the police department keeps because they have to keep a record of when they have someone in custody. Where is that person? The problem is the discovery law says those are related. It is related in that it was generated because you were arrested. And the law is inflexible. If we fail to get those reports, the case is dismissed. There's a court of appeals case that should have fixed this, but in our courts, it has not. We'd like to codify that into law so the judges have to listen to it rather than reinterpreting it. So we had a case a couple of weeks ago where I had to sit with the father of someone who had a person take their pants down and masturbate in front of them on the subway, grope the young woman in front of her father. We failed to find the pre-arraignment report. Nowhere in that report did it say anything about guilt or innocence. Here's what someone saw. It just said where the person had been after arrest. That case was dismissed. Got to sit in a room with that person and say, in no other state but New York would this happen, but your case is dismissed. And that's the other point here. Unique to New York and unique in the law is this mandatory dismissal sanction. What we are seeking is a provision that says you cannot get the massive relief, the kind of windfall lottery ticket of case dismissal for discovery noncompliance, unless there has been prejudice that can't be cured. And what that means is we don't give you something that says there's a video camera on 34th Street and the video gets deleted by the time you get there. You've been prejudiced in a way we can't fix. That evidence is gone. That case is dismissed. But in a case where we didn't have the pre-arraignment report, that young woman likely would have had her case adjudicated on the merits. Because they would have said, is there prejudice to you here, defense lawyer? What is really the problem with you not having gotten this pre-arraignment report until after the deadline? And there really isn't one. And we know this because those are not the documents demanded in homicide cases, which don't have speedy trial clocks. All of these documents can lead to speedy trial dismissals. Homicide cases don't have a speedy trial clock. No one's ever asked me for these administrative documents on a homicide case because they are not useful in defending a case. They are useful in getting a case dismissed on speedy trial grounds. And I'd love to take questions. I don't know the format, but the last point here is the speedy trial point. And I think it's the one that makes New York's law so pernicious. We have one of the most strict speedy trial regimes in the country. I imagine the defense lawyers on this call would not trade it for any other states. We have probably the most aggressive and anti-prosecutor speedy trial laws in the country. What the discovery statute did was link discovery compliance to the speedy trial clock. 49 states in the federal system do not do that. 49 states in the federal system do not dismiss cases because of discovery violations absent bad faith or misconduct. We are unique in this respect. The most recent case that we really had to sit down and have a tough conversation with someone on was a rape in the first degree case. Someone was forcibly raped by someone that they had met on a dating site. The ADA and detective had both shared messages kind of outside of formal systems through text messages, talking about scheduling. Can you be here on Tuesday? No, I can be there on Wednesday. And in one or two of the responses, the victim wrote back how hurt she had been by parts of how the case had played out, which is related, right? She's discussing the case. It's related to the case. We didn't provide those, and a judge dismissed that case. In every other state in the country and the federal system, that rape case goes forward. Maybe it's an acquittal, maybe it's not. Maybe in another system, the judge says, these text messages should have been turned over. You get to cross-examine more about them. The jury gets a negative inference about them. I'm going to preclude parts of her testimony that relate to them. Those are remedies that are proportional to the harm. In New York, that case is dismissed. The Court of Appeals, and to be fair, the legislature tried to fix this in 2022. They put in language in the discovery statute that said there should be no adverse consequences when we act in good faith and with due diligence. The problem is they didn't put it in the speedy trial law. And we can tell it didn't matter in 2022 because when they put it in the discovery law, there was no objection. We want to put the same logic in the speedy trial law. Now there is an alliance. People are calling us liars and disgusting on TV. The rhetoric has gotten, beyond overheated because this would actually reduce case dismissals and it would force us to adjudicate cases on the merits. I don't know how much more time I have. I don't know if there are questions. I can talk about this for days. I have deep respect for Callie and for Amanda. I think we agree on probably more things in this world than we disagree. This is one where, when we saw these proposals, it shows the gulf between practitioners. To me, I look at this and say, I'm still begging and pleading the governor to give us the most anti-prosecutor law in the country. And we're being met with, this is going to destroy criminal justice for defendants as we know it. That saddens me. I don't think it's the truth. I think, the number of dismissals we have now, which are up from 28% of felony arrests to 42% of felony arrests ending in dismissal, is not a tolerable place for the system to be if those dismissals are the result of this kind of endless search for administrative nonsense. I think the governor's proposal strikes a great balance. We remain the only state to tie discovery compliance to speedy trial law. We remain the only state with dismissal as a meaningful sanction for discovery noncompliance. We would lead the country in terms of how open and transparent our laws are. If you pass the governor's bill and let me throw a dart at a dartboard at every other state, I'd take every other state's law over this one. So this is not a friendly statute for the prosecution as amended. And I would love to be pointed to a state who the Legal Aid Society would trade with, both the speedy trial and discovery regimes. Let us know, because we'll switch laws, both of them together, speedy trial and discovery. Where's better for the defense than New York than under the governor's proposal? It's a nation-leading law. I'm sad we can't come to agreement on this, but we have lots we have to work on together. And I hope that despite the disagreement here, it doesn't spill into other parts of our world. But if it's a Q&A session now, I'm happy to answer, or I'm happy to yield to Amanda and Callie.
Q&A, but we're going to let Callie take her turn. We're going to give you a chance to respond to what she says and her to respond to what you say. And then it's open. It's an open floor. Go ahead, Callie. Thank you. And if you have a slideshow, we can let you share the screen.
Thank you so much. So we do, and I think we kind of misunderstood that. It's our fault for miscommunication, but I think I was just going to respond out one thing, and then I'm going to turn it over to my colleague Amanda to start off the presentation. But I just want to say, yes, Andy, we would trade other states' laws, because to be clear, in other states, and I just want to, this is like a thing that, my job at Legal Aid is to train our new attorneys. So I talk a lot about speedy trial, and it is incredibly complex, and I'm not going to try to lecture you guys about how our speedy trials work tonight. But what I will say is that actually our state is the only place in the country that doesn't actually measure speedy trial by whether a trial is taking place. So you could still, a prosecutor could be following all of the rules and the case could go on for 3-4 years. And that wouldn't matter, right? The fact that a trial doesn't occur in 3 or 4 years doesn't mean that they didn't get a speedy trial because it's not measured by a straight clock. If you go to most states in this country, the way their systems actually work is they have a 6-month time frame, just like we do. Some are a little longer, right? It depends on which jurisdiction you're in. I know in Massachusetts, for example, it's 6 months. In some other states, it's 8 months. In some other states, it's a year. But it's a straight clock. They get that much time, and you will literally go into a courtroom, and if after the arraignment, and there may be some administrative adjournments in between, but after the arraignment, if the case goes on for 6 months and the prosecutor isn't ready, the case gets dismissed. And that is simply not how it works in New York. And in New York, the reason that so many tragedies happen, like Khalif Browder's, right? That so many people are locked up for, or have been, right? And this law went a long way, in our view, to fixing that problem. But for so many years, so many people were unjustly incarcerated for a very long time, like Khalif Browder was, in large part because of our speedy trial system, because of the rules that are actually quite friendly to the prosecution from our perspective. Because what they do is they allow a prosecutor to state ready for trial and then stop the speedy trial clock, even though we might be years away from a trial actually occurring. So I just think it's really important to understand that when we talk about our law as compared to other laws. And yes, we don't tie discovery to speedy trial in other states, because in other states, you get your trial within a year. And in other states, there's also generally has been a culture for decades, unlike in New York, of open file discovery, where people can go to the prosecutor's office and copy all the files, and the prosecutor gets the whole file from the police, right? There is a different culture in New York that we're fighting against. And with that, I'm going to turn it over to Amanda. I think we're going to, throughout the presentation that we have, address a lot of the things that Andy raised. So I won't go piece by piece now, if that makes sense with you, AJ.
Yeah, and I just want to apologize. I live in a 1-bedroom with 2 small kids and it's bedtime. So I'm sorry to be walking around trying to find a corner. Oh, New York City life. Thanks. I'm Amanda Jack, AJ, a lot of friends call me, and I've been a public defender since 2011. For the past 2 years, though, I've been directing our policy. So I am up in Albany a lot and dealing in the statutes and defense, because that's kind of where the defense, and we're almost always defending any small gains we get. So Stu, you gave a great overview of discovery. I don't really want to belabor this, but just, keep in mind, it does include all of that. Other states, like say Florida, for example, would allow you to actually depose, ask questions of the police or the accusers before trial. So there are much more open discovery statutes out there too. Why we needed the reform, we talked about it. Andy talked about it too. And I think this is a point of disagreement, is we do feel that this sweeping proposal, which is so much more than talking about administrative paperwork, which doesn't even include the codification of the case People v. Bay that clarified the standards. It doesn't include that. It goes so much farther. And it goes so much farther that it will get us back to these days. And it will make it so that we are chasing evidence, and not with every prosecutor, right? Not every prosecutor will withhold it, but that's how it used to be too. Not every prosecutor withheld, but I sat in Manhattan courtrooms and got dumped 800 pages, of discovery over and over, because they could be withheld until the jury was coming up. So before the hearing, or after the hearing, that was a reality, and that is within my span. I haven't been a defense attorney for that long, right? It's only been since 2011. And I just want to say, like, that's why we feel, I get what Andy's saying about the hyperbole, but it's on both sides, and some of that is perspective. But what we're talking about is, if you or your loved one were accused of a crime, you'd want to see all the government's evidence against you. And that just was never possible before the reforms. And this sweeping repeal that Governor Hochul has proposed, that includes a lot of suggestions from DAs across the state, right? It's not just from DA Bragg's office. It's incredibly sweeping. We feel solidly that it will take us back to that time before reforms. And I'll just say too, this is a longer seminar, but prejudice, like that last point on this slide, is about the way that the prejudice was cured, and it's not a straight example, like Kali said, because our speedy trial statute is really trial readiness. The way it was cured was by delay. And the chief administrative judge of OCA gave testimony at the public protection hearing on February 7th. If you're going to take a vote and stance on this, I highly recommend watching that hearing. He talks for like the first hour and a half. And Judge Zaya said, like, that's what it was. You could always cure it. You could always cure when defense said, oh, I didn't get this. You could always cure it with more delay. And because the prejudice was fixed by having time to look it over. Wasn't perfect. In some cases, we lost an opportunity to investigate, to have maybe a medical doctor look over injuries, etc. But we could at least say, like, I can't proceed in this trial in this moment, and that we get an adjournment to like the next day.
Yeah, and AJ, can I just jump in for one thing? I just want to make sure it's clear, right? The proposal, so what Andy was mentioning was that what they are seeking to introduce, I think something that is in the proposal and that all of the DAs agree that they want is an addition to the standard of when a discovery violation can be punished, right? That rather than it being dismissal if they fail to comply within their speedy trial timeframes and the judge finds that they weren't diligent, it would require on top of that that the defense have to demonstrate prejudice to the defense in order for the dismissal to occur. So what AJ is saying is that that is our old system. That is the system that we had before that led us here, because the way judges always cured prejudice, and what Judge Zayas was saying, is the way that the prejudice was cured was through an adjournment, through more delay.
We're gonna.
No, and can I just, I would really love to ask something that I think might prevent some questions later. You're saying a lot of they and the proposal. And my understanding is that there are multiple proposals and that there are multiple theys. So as you go forward, it would be helpful if you could be explicit about what you're talking about.
Thank you. That's really helpful. Go ahead, AJ.
Well, let me table set then too and say that the proposal that Andy and DA Bragg's office is asking you to accept is the governor's proposal. I would think, and Andy, happy to unpack this, or Eric later on, because you mentioned some other ways that you think you could cure this through legislative change. That's not in the governor's proposal. The governor listened to DAs and to the District Attorneys Association of New York. We actually are very lucky. We have gotten a regular line of communication with the governor's public safety team. I personally asked month in, month out at those meetings if any discovery changes were being considered, was told no. We had to find out about this through people in the legislature right before it was announced. So I just want to make clear that they is Governor Hochul and DAs from across the state, including the District Attorneys Association. We can kind of skip through this because this is a lot of what Stu talked about too, but we think the discovery reform has balanced the scales. But I will say what the truth is about any law that is changed after decade upon decade upon decade is it takes time, right? So the case that Andy mentioned could be codified where it spells out what diligence is, right? What factors go into a judge deciding if a prosecutor's done their job. That was just handed down in December of 2023, right? Because we also had 2 years of ineffectiveness of the law because of COVID, right? The speedy trial laws were suspended for 2 years. So a little less on misdemeanors, but there was a suspension there. So we're all kind of digging out of the numbers of those errors and whatnot too. So as with anything, the law takes a long time to settle, to be clarified. And the Court of Appeals, our highest court in New York, did do a lot of clarification that was handed down in December 2023. Go ahead, Kali. And then this is probably the most responsive to what Andy said too. And I'll kind of go through because I want Kali to get to the data, because I think that's important, because we've heard some anecdotal reasons why you should consider this, but the data I think tells another story. And we really caution you, no law should be changed based on one case, even though there are tragedies that happen, right? I think that's always the push-pull of government. I think we already discussed this. We're not an outlier. We're one of 40 states that have open file discovery. And if we did go back, this repeal that the governor is proposing would allow prosecutors and police to withhold evidence. Again, not saying everyone will, but it will allow it. And that's how it used to be. And no, not every prosecutor withheld evidence, not every police officer in a case, but it happened so often that we were still like one of the top states with wrongful convictions, right? The majority of wrongful convictions and exonerations in New York State are because of withheld evidence. And that's just an important thing to keep in mind. There are still people in prisons today who have these kinds of claims and are waiting for the appellate courts to hear them out. The second thing we're hearing is about, and this is, Andy, you talked about this too, like the failure to disclose administrative items. This is inaccurate too across the board. Cases in the large part are not dismissed for failure to disclose minor items because that is not what the Court of Appeals has clarified. Now, have all the trial courts caught up? Andy's citing to a couple cases that, recently they've had, I'm sure they've had others. So the answer is no, right? This is a case that's now a little over a year old that's still working its way down through and clarifying. But the Court of Appeals in that case, that quote that's on the screen is from that case. There's no rule of strict liability. That is that the statute does not require a perfect prosecutor. So what that means, and again, if you look at Judge Zayas' testimony on February 7th, he said the defense would have to show to get a case dismissed on a technicality that the prosecutor did absolutely nothing. And that's just important to remember because we're talking about a diligence standard. And to that end, and we'll talk about this more, yes, we want better access for the prosecutors with the police department. We don't want it to be that they call the police 10, 12 times and can't get items. That's not okay. That can be fixed and there's common sense solutions for that. And then the final claim that we are here to rebuke too is that are these very short timeframes. So there are timeframes in the statute that are actually 20 and 30 days. No one actually adheres to those, and there's no enforcement mechanism for it, which is one of the reasons they're short. But the timeframes that we want you to understand are that on a misdemeanor, you have 90 days from the date that you're arraigned. After the arraignment, you get arrested, you get arraigned, right? 90 days on misdemeanors. And you have 6 months on a felony case from arrest just to get indicted, not for the case, like the case has to get indicted and then it can go on. 6 months. Indictment is, of course, the grand jury deciding that there's enough evidence. And then homicide cases, just to also please keep this in mind because we saw this in some of the fact sheets, homicide cases are not subject to these timeframes at all. I've worked on a homicide case. Discovery doesn't have to, there's no time frame for it. There's no enforcement mechanism. So keep that in mind. Or go ahead, Kali, make it.
There's no speedy trial clock on a homicide. So the speedy trial rules don't apply to a homicide. The discovery rules do. But yeah, sorry. I just wanted to make sure that
this is why I bring the supervising trainer along too. So go ahead, I'll pass it over to Kali to finish off so we can get to questions.
Yeah, and I'll be brief. I do want to just also say that, like, I want to talk about the data, but we also consider the cases to be data. And I think that that's really important because, I'm not questioning, Andy, that there are questioning the cases that Andy referenced, although I'm not familiar with those decisions. There are, as AJ said, still judges who are outliers within our courts who are not, maybe up to speed. And maybe one of the things that the legislature should focus on is training for OCA judges. But I think that, if you look at the published cases, which I've done, and I do it's a huge part of my job, the sum total of them, like the vast majority of them are applying this standard from the Court of Appeals. And frankly, I personally have helped attorneys litigate cases where there were pretty egregious discovery violations. I had a case where, multiple detective reports and recordings were withheld and not disclosed for 2 or 3 months after the speedy trial deadline. And ultimately, the court decided, well, we think the prosecutor demonstrated that they were diligent, so we're not going to find that that they didn't follow the law, and we're not going to dismiss the case. And so, if you're going to look at if we can look at random examples, but I think it behooves you to look at sort of the numbers in terms of those decisions, because I think somebody said it when they were talking about, I was here for your conversation before this one. And I know somebody was talking about how, you can't use one extreme example as a reason to make a policy decision. And that's sort of how we feel about this. Like, we're not going to dispute that there are a couple, there are some cases that are dismissed that maybe shouldn't have been, but that doesn't mean we should throw the law out. And the fact is that I think what is disingenuous is any representation that there are, that the numbers, because we're about to talk about this data, the numbers of cases that are being dismissed, that those numbers that were cited of felony dismissals, that those are being dismissed based on emotion or based on these sort of administrative documents not being turned over. That is false. And that's provably false. And so I just want to sort of give you that context. And so we've sort of said this, but just to be clear, like speedy trial, because of the way the statute operates, speedy trial dismissal numbers are the only ones that are accurately linked to discovery violations. So it's when you look at any publicly available data, it's really only those dismissals that matter. And the part of the problem with the data that's out there is that there wasn't consistent, and OCA will tell you this, there wasn't consistent reporting requirement. There weren't consistent reporting requirements by OCA to its local courts to track the reason for a dismissal. So speedy trial dismissals prior to 2019 were not being consistently tracked. So the data is not perfect. Let me just put it out there. We're not disputing that there has been a rise in New York City of speedy trial dismissals. But with that said, like, we don't know how extreme it actually was. And even with that discrepancy, in superior courts where the most serious cases are tried, right, where cases that have been indicted that have gone through that process that AJ talked about, those cases are still the speedy trial dismissals make up less than 0.5% of all disposed cases. It is incredibly uncommon that those cases get dismissed. Okay, so what I'm saying is, like, the main increase in dismissals is in local criminal courts where misdemeanors, violations, so very minor offenses, and unindicted felonies, which we'll talk about, are prosecuted. This is just a chart from OCA. There's a discovery dashboard. You guys can go to it, and if you so choose to. I know it's maybe only interests me obsessively, but you can, control for a region. You can even limit it to New York, like to Manhattan, and you can look at Superior versus criminal court, and you can look at the case types, felony or misdemeanor. And when you do that, and you look at the cases prosecuted in Superior Court, which again are the most serious cases, when you compare 2019 to 2024, this dark blue number represents the speedy trial dismissals of indicted felonies. So you can't even, it's such a small number, it doesn't even show up on the chart, right? 86% in 2024 and 86% in 2019 were both other dispositions, which are largely convictions. Or acquittals after trial, there might be acquittals, but like either it went to trial or it was a plea. So I just want to give you that for context during this discussion. Now, there's a discussion about unindicted felonies, which don't go to Superior Court. And I know that Andy, we've talked about this, but there is prosecutors get, as AJ said, 6 months to present evidence to a grand jury on a felony to secure an indictment. What you need to understand is that discovery is not required to be shared with the defense prior to an indictment. So, and we, according to the criminal procedure law, are not allowed to file motions to dismiss under the speedy trial statute until after a case has been indicted. So those cases that are getting dismissed in criminal court that started as felonies were not dismissed based on a motion by the defense because of some technicality. They're dismissed because prosecutors choose not to pursue the case. And as Andy will tell you, right, they are triaging. They're saying this is too much work. We can't indict all of these cases. And before reform, they were indicting the same number of cases, but more of the unindicted cases were being resolved with pleas before they had to give the defendant the evidence, before they had to do much work on the case, if we're honest, right? They didn't have the capacity to do the work it takes to indict a case, bring it to trial, give all of the evidence to the defense, and they relied on many of those cases being resolved with pleas. The discovery reform, in a positive way, made it so that we don't have to do that anymore. We don't have to take pleas before we see the evidence. And so that, that this is the result of that, essentially. Any sort of increase in the dismissal of unindicted felonies is because of that. And the solution, if they don't want to, if they don't want to dismiss that many, is just to spend more money. They've been given tens of millions of dollars, and they can hire more ADAs and support staff. So I know I'm almost out of time, so I'm just going to rush through the end. But basically, I just want to be clear that this is a New York City centered problem. Upstate, out of the city, cases are not being dismissed. So something is going on in New York City. As you can see in some of these big out of state population centers, like in Erie County, in Monroe, where, Buffalo and Rochester are, there's actually been a decrease in dismissal rates since 2019, before the reforms went into effect. So there is something going on in New York City, and and I understand, Andy may not say this, but we suspect, because of our experience in court and what we hear ADAs saying in court, because they are trying to comply, we suspect that it's NYPD, that they're over policing minor crimes, which increase the volume of cases that ADAs have to deal with. And they're very resistant to evidence sharing. And so things like misconduct records, as Andy was referencing, which are very important in a case, are very closely guarded by NYPD, and they refuse repeatedly to turn them over. And so this is something that requires a fix that is specific to that from our view. And there is a bill that is not in the governor's proposal that would fix that. And that makes sense, right? It gives prosecutors direct access to NYPD, at least in New York City, NYPD, but across the state, other police agencies, access to their evidence databases, so that they don't have to rely on the cops giving it to them. Now, lastly, I know we've been talking a lot about what are the justifications for this? We don't have time to dig into all of the technical ways in which this proposal will effectively repeal the reform, but it is not, there have been news stories that say these are tweaks, that these are small changes. They're really, really not. They are effectively a repeal. Even though the list of items hasn't changed, the list of items that they're required to provide to the defense hasn't changed, all of the incentives for actually doing so and doing so effectively are removed essentially from the statute by the imposition of that prejudice standard that Andy was talking about. And further, the fact that they're not requiring prosecutors to turn over anything that's not in their actual possession enables the police to withhold evidence, because there's no punishment for a prosecutor or the prosecution in general or law enforcement for not sharing something. So I just wanted to mention that. And, ultimately, change is really hard for all of us. This was a big change for the defense as well. We had to take on a lot of resources and make a lot of changes to make this work. But, this has been a slow rollout. And as AJ said, we only got the first case from the Court of Appeals interpreting this in 2023. And we just need to give it more time. And we need to continue to fund it so that we can make it, effective. And not also, just lastly, we can't, even though I know this is a community board that's focused on your neighborhood in New York City, we don't want people accused of crimes in places with less progressive prosecutors and with, potentially, I don't want to speculate about any one particular county, but we have friends, we work with defense attorneys upstate, and they work in places where their clients would be in a really bad way if this law were changed. And so, this isn't a city law, this is a statewide law. And we just want to make sure that that's kept in perspective. Okay, I'm going to stop sharing my screen now.
So thank you. Thank you both for sticking to my 7-minute limit. Fortunately, it was engaging enough that it was worth it. Andy, it's up to you to respond for a couple of minutes.
I'm really sorry to say I've got, there's a childcare mess outside my house too, and I've got to relieve my wife in about 6 minutes. So what I'd rather do is say, for anybody who has one thing that would help for me to try to explain, to respond to, I'd rather respond to the things that are in your heads than try to guess. So if somebody's got a question, I'd like to field it. If not, I've got, we've had this argument, we're gonna do a traveling roadshow, I'm sure. We can go back and forth, but if there's something on someone's mind, I'd rather start there.
Okay, let's open it up to questions here. Go ahead, Justin.
Yeah, so, firstly, thanks for taking some time, sharing your thoughts. You mentioned that the pre-2019 laws were rather draconian, unfair, I should say. Would you say that there are elements of the new proposal that might also cross what you would consider, not
No.
things?
We didn't borrow a word from the old article was Article 240, the new one's 245. Article 240 was was a, system in which the defense had to demand things. The new one is automatic discovery. We retain automatic discovery. The old system didn't have a dismissal sanction. The system as changed by the governor would maintain mandatory dismissals in the only place in the country. And I don't know why we keep talking as if there is no other sanction that keeps people honest, right? We don't hang people for stealing. There are proportional sanctions in many parts of the law. If you violate the discovery law, why does the judge have to reach to now this case is over every time? What we want is for a judge to be able to say, this one's bad enough that the case is over. That one, this case can survive. And there still is a duty. This gets ignored all the time. We still cannot declare ready for trial without a certificate of compliance signed by a member of the bar under oath saying, I have done a good faith and diligent examination of the evidence. I understand that, the Legal Aid Society has so little faith in prosecutors, they think that people are going to lie under oath. The system can't work that way. You have to sign a document saying to a judge, I, an officer of the court, swear I have done a diligent examination of the evidence in this case. So no, I don't think it restores that. There was a claim that what this does is establish open file discovery. There are tweaks from state to state, but by and large, what open file discovery means is if the prosecutor has it, the defense has it. This law goes way beyond that. The law that we currently have says, again, and I can't say this confidently because I don't know this is unique, and I think North Carolina has it too, but our law, unlike most every jurisdiction, says we assume the prosecutor has everything the police have, even if they have actual access to none of it. So there may be a state beyond North Carolina, please keep me honest, but that's not unique to New York, it's just somewhat uncommon. We had talk about, there's funding that can get us past the change from 240 to 245. I'd note that when 245 was passed, it passed with $0. No one funded anything to do this because, I have my own suspicions about what the intentions of the law were, but lots of cases got dismissed and more would have if COVID hadn't happened. And we told the speedy trial law for a while. So, I don't understand the proposition that this takes us back to an age where discovery was behind a wall, when in every case before a speedy trial declaration of readiness, someone has to swear under oath they provided the evidence. I also find it, somewhat frustrating to say what we need is to get the fundamental evidence in front of someone. There's history here. In 2022, when some amendments went through, we proposed, let's make a smaller list of evidence of stuff that really matters, right? The video, the detective reports, the witness statements, and let's say once we file that, we can stop the speedy trial clock. And we were laughed out of town. And by the way, we got the same responses. That is reestablishing Article 240, and we're going back to the bad old days. So there's kind of, in all respect to you guys, there aren't many changes we can propose that are not met with, you want to go back to the bad old days. And there's been a desire to say we can throw money and people at this for the last 4 years. I'm in charge of dispersing the money for this at the DA's office. I can tell you, if you give us $20 million more, the same number of cases will get dismissed next year. And I want to show you the kind of rest of the data because this point about, superior court dismissals have not increased. That's true because we don't indict cases we can't get compliant on. And the analogy I would use is, if a hospital cures 30% of people today and they cure 30% of people tomorrow, but they're turning away twice the number of people at the door, that's not a hospital that's performing at the same rate. And what we've done to comply with these discovery laws is we've started downgrading felony cases and leaving them in the lower courts at clips that are not responsible. And if I can share my screen for a second, I'll show you the kind of gross dismissal data we're talking about, which is here. So here's the inferior court dismissals, right? We said before, you saw the chart with no changes whatsoever to superior court dismissals. That's true. Those are cases we chose to indict. And there are flaws in the data where you don't want to do too much parsing. I agree with my colleagues here. But in 2019, gross dismissal rate, all dismissals from all reasons were 44%. That now stands at 68%. They've gone up by a factor of 1.5. That comes from somewhere. It's hard to say it's unique to New York because the lower court data in upstate courts is in town and village courts in a lot of cases. Not every one, I see you shaking your head, but it's in a lot of cases.
I have
look
it,
at this.
Andy, and they're basically zero,
Oh,
literally
okay, well,
300 across the state.
Okay. Well, I mean, I've said I didn't think anybody had that answer because the data's not there. If we have the answer, we have the answer. But we've gone from 44% of lower court cases dismissed, which include not just misdemeanors, but unindicted felonies, from 44 to 68. And when I hear that this is just a misdemeanor problem, I mean, I kind of want to jump out of my skin. Most of our domestic violence cases are misdemeanors. Sex crimes, like the woman who got groped on the subway, are misdemeanors. Every case in which somebody walks up to another person in New York and punches them in the head is a misdemeanor. That's assault in the third degree. So there are cases that matter in that data, and those cases are being dismissed because of the discovery laws. We see these every single day. And we're going to retrain the judges is great. I don't think this is due to bad faith or anything, but the Legal Aid Society's motions as of 2 weeks ago still say the standard is not due diligence. They do demand a strict liability, perfect prosecutor standard. So we're still getting these filings. There are appeals courts that are striking them down, but appeals courts can't strike them down unless the argument gets made in the first place. So I don't think we're in a place where this law is workable without the kind of current problems. And the last data point I'd end on, and I'm really sorry to have to leave, but yes, we indict the same number of cases in 2024 or so as we did in 2018. In 2018, the crime rate was akin to 1942. We've had a change in the crime patterns in New York City that probably call for more indicted cases, but we haven't gotten. And I can tell you, you can believe us or not, but the best perspective I can give you from inside the DA's office is that the reason why is because of the discovery burdens we're under.
My understanding is both sides favor or support, it's S613, right?
We do in Manhattan. I can't speak for all the prosecutors. I think it would be helpful in conjunction with the governor's proposal. On its own, I don't know how much it does.
Okay,
All right.
please go ahead. Sorry.
So it seems like you kind of both agree on the basics, that people need information to understand why they've been indicted for or arrested for a crime, right? I mean, that's the foundation. So my concern about the language of the new language is that we have to trust completely, which can be a problem, a prosecutor to decide what is relevant to the case. And so to me, it seems to me like you got two people, you're lovely people, all of you. You're sitting down, you each have the same case. Why can't you just talk to each other and say, this is what we both decided is relevant to the case, and let's get that information? So I'm unsure what that really means, and it's concerning.
Can I jump on this for one second? Because I have to leave right afterwards. You can answer, and Eric will tell me what you said. But I do want to answer this one. This is another argument I don't quite get, because when we're going to change from related to relevant, we're worried that a prosecutor has to determine what is relevant. Right now, a prosecutor has to determine what's related. It's not a change to the structure. And unless you give somebody kind of blanket access to every file inside the police department in every case, the prosecutor has to play some screening function. Here's what this case is, and the things from that date and that address and that 911 call. That is deciding what's relevant and what's not. Maybe there was a 911 call one block over and somebody witnessed something, but at some point you kind of have to draw a boundary. So that concern, if you have that worry, it exists now because we are tasked with determining what is related. And ultimately a judge says whether we're right. I don't determine if something is related or not. I submit it and say, Judge, this is what I believe to be related and I think I'm done. And a judge says yes or no. Under the change in language, which frankly, I don't think our office cares a whole lot about the related to relevant change. I don't find it that meaningful. It causes a lot of worry on the part of the defense bar. So, if I was the legislative strategist, I'd say, let's leave it. But, there are 62 DAs and I don't represent all of them. But that screening function is always going to exist. So, unless you just have somebody look at a kind of total information awareness system of the police department, somebody's always saying the boundaries of this case are here. And Eric, he's armed with a lot of these answers. I'm really sorry, everybody, but I've got to tune out, and I'll try to catch up with him later. Thank you so much for your time.
Thank you, Eric.
Thank you.
You're going to be, this is your opportunity to stand in. But let me invite the Legal Aid Society to respond.
Thank you. I mean, AJ, I don't want to, you can take it. I just wanted to that last point on the relevance. I just want to say one thing. I think you were really right. I think to see that as important, it is one of the things we are most concerned about. And this is not an indictment of ADA Warschauer or of any specific DA, right? This isn't about us thinking they're bad people or that they're not going to be honest. It's that they have a view of a case that is unique to the prosecutor. They think about what is going to make my case more or less likely to be true, and that's all they're thinking about, right? And they're concerned about their theory of the case. My complainant says that this is how this robbery happened. And that is the story that they are trying to prove or disprove, right?
Yeah.
Meanwhile, my client is telling me, oh, no. I was over on, 3 blocks away, and I heard from a friend that this other thing happened and that this is how it went down, right? I am not going to be sharing that because everything my client tells me is confidential. I'm not going to be sharing that with the prosecutor. I can't. So if I don't have a view of the evidence, they might disregard something as not relevant that is actually confirming what my client told me. And so that's just an example, but it's really important that the defense be able to see everything that is generated or at all relates. And contrary to what ADA Warschauer was saying, it's much easier to decide if something generally relates to a case, like it was generated in connection with a case by the NYPD or collected by an investigator, than it is to decide what's relevant and what's not. And to finally just put a pin on that, the main concern that's driving this is that these cases are being dismissed because they're not providing evidence. The problem for me is that if they have access to the evidence such that they can actually make that determination as to whether it's relevant or not, then they should just turn it over. What's the point in keeping it to themselves? The issue they're saying is that they don't have access to it. And so if why do we need this sort of screening mechanism if that's the real concern? Because let me tell you, even now, we have prosecutors who claim when they can't get something from NYPD and they're worried about their case getting dismissed, we hear from prosecutors, oh, judge, it's not related to the case. But how do you know that? You've never looked at it. Right? And to answer your question about us coming together, we can't come together if I don't have access to the evidence because I can't argue with them about whether or not it's relevant without seeing it. So it's, anyway, I'll turn to AJ and let her respond to others.
I just wanted to say too, one of the other proposals that the governor's made that the DAs are supporting is this redaction proposal, which, Andy just said the judge gets to determine what's relevant. The governor's proposal allows DAs to redact without judicial oversight, right? So right now we can say, hey, judge, can you just check what they're blacking out just to make sure it's not something that might need to be turned over? And this proposal would change that, would make it so they have unilateral power. And the New York State Bar Association, who's not the most liberal organization, I say this as a member, right? Back in 2014 or so, did a report on discovery because everyone was talking about it and said one thing that we can't, this is Avenel, one thing that we can't do is give that kind of discretion, right? Because there's a view of the evidence that's toward guilt, and that just is common sense.
Eric, do you feel comfortable as a understudy here, or is that?
I mean, if I were to actually answer that question, Stu, it would probably be no. Just for full disclosure, I'm not an attorney. I didn't go to law school. I supervise our community engagement with the office. I think I just wanted to also highlight for the group, Andy would be available at a later time if we had some other questions. I obviously don't want to take Callie or Amanda outside of the conversation, but happy to, whether it's in written form or a follow-up call, happy to circle and loop Andy back in. The only other things I wanted to highlight too is, I think that when it comes to basically the level of, essentially the penalty that's imposed for the discovery obligations, I think that there is, when you're talking about discretion, I know Andy already said that there are other remedies potentially for discovery violations for some of this other information. I just think that just to highlight and underscore, and I'm sure Obviously, legal aid has a different perspective on this, but the summary case dismissal as an order of law is simply, it is not necessary for all of these different categories of cases or gradations of evidence. The fact that that is the violation or the penalty that's imposed for across the spectrum of different violations, I just wanted to emphasize and highlight. I know also Andy shared his screen before. One thing that I wished that Andy had mentioned, if I can really quickly share the exact same thing that Andy had up, which is just this right here. Andy did mention these case dismissals right here, right? But I wanted to draw everyone's attention to specifically to the 30/30 case dismissal rate in the dark blue on the left. This is what we're specifically talking about with speedy trial dismissals. I know Andy mentioned, 44% going up to, what is that, 38%. But we know, too, that the 30/30 case dismissals go from 5% in 2019 all the way up to 31% just last year in 2024. So again, just wanted to highlight that as well. What we're specifically talking about here lays within the confines of the 30/30 dismissals. Again, happy to bring Andy back. I want to highlight, too, though, when we're talking about local court, when it's misdemeanors, when it's non-indicted felonies, as Andy mentioned before, yes, these are lower level cases, and I think Andy did a really good job at kind of painting this picture. But each of these cases, there's a victim behind it, and there's somebody who, as Andy mentioned, would potentially be able to seek justice in these other states and is unable to do so in New York State, specifically because of these discovery laws. They range again from domestic violence cases to assault threes. It has a huge impact on shoplifting too, an issue I know is really relevant to the CB6 area and other things that impact quality of life. So again, just wanted to highlighting a few things that Andy mentioned. I would say I'm not equipped to enter the ring here, but I at least wanted to make a few more points. And again, we can circle back with more information. I'll stop sharing my screen right now.
And I know that we've taken up a ton of your time and you probably don't have much more to give on this. I just have to quickly correct one thing or two. First of all, there is data that breaks down what the charges are in these cases that have been dismissed. And that's a gross exaggeration to say that there is a victim behind every one of these cases. At least half of these cases are vehicle and traffic law infractions, like driving with a suspended license, shoplifting, like minor shoplifting cases, like very not to say harmless crimes, but cases where there is not an individual person who is a complainant, where there is not somebody injured. Many domestic violence cases are not involving physical injury, are not involving violence. They are, harassment, where people are, again, maybe a matter of opinion, but people are over policed because their neighbors hear them fighting, or there are, people breaking each other's property. Not to say that these are things that are okay. I just don't want there to be a misrepresentation that like there is actually somebody assaulted in behind each of these dismissals. And just also to point out that there has always been a very high percentage of domestic violence cases dismissed long before discovery reform. And that has to do with the fact that complaining witnesses often do not cooperate. And so when they don't sign, and that's its own issue that I'm not trying to say is not a problem, but it has absolutely nothing to do with discovery, right? It's because for a variety of reasons, people do not continue with the prosecution. And so even in 2014, there were 71% of cases dismissed for speedy trial reasons in the domestic violence part in the Bronx, for example. So I just want to give you that context when we talk about this. The other thing I want to just quickly go back to is the mention of sanctions. So this idea that okay, there will be meaningful sanctions for belated disclosure of discovery or for withholding of discovery if we don't have this quote unquote automatic dismissal. That relies on two sort of red herrings that aren't accurate. One is that there is such a thing as automatic dismissal. There is not. A judge has to, if we make a motion to dismiss, the judge has to review what the prosecutor did and decide whether their efforts were sufficient to justify the fact that they got the discovery late. Yes, there are a few cases where that standard isn't perfectly followed, but the vast majority of cases, In the vast majority of cases, it is. And most cases where motions are brought are not dismissed. We have to bring those motions to preserve our clients' rights, but that does not mean that that the law itself shouldn't be operative. The other thing is the sanctions, and that is a sanction can be an adjournment of a case. A sanction can be the preclusion of evidence. The sanction is not meaningful unless it actually provides a consequence that the prosecutor is looking to avoid. And when a prosecutor, for example, provides the late disclosure of evidence that might be useful to the defense if they had a meaningful time to review it, a judge, if told, is going to be the preclusion sanction, for example. That's one of the ones that's most frequently cited of, okay, prosecutor, you turned this over right before trial. Now you can't use that evidence, is the opposite of helpful to the defense. Because we might have actually wanted to use it ourselves. We might have wanted to do more investigation using it. We might have wanted to send it to an expert, and now we can't. So that was one of the many reasons that the old system was so problematic, was because the only the system for policing discovery violations was using this prejudice standard that they now want to reimpose. So yes, they're not trying to limit the scope of the materials that are discoverable, but they want the sanction scheme to be exactly the same. And that is where all of the problems lie, in my view. And AJ, did you want to add to that?
So Andy said that he supported S613, but just as one element. How far do you think S613 would go in curing all of your concerns? How close would it come?
That's what I've been wondering.
Yeah.
Yeah, I mean, I think it's the direct access. Like right now, that's what should be happening. But NYPD is famously not liable to laws all the time or oversight. And not to get into that, but it should be happening now that they're sharing this. And I should let you all know too that we've gotten millions of dollars, and the DA's got it first. Then we were like, hey, what about us? We have to review the same evidence. So we've been getting it too. And at Legal Aid, we have gotten the same digital evidence platform as the DAs, and that NYPD has long had access to. And if you think the DAs and defense have gotten a lot of money, NYPD has gotten even more. And the fact that Commissioner Tisch was like the guru, right, of digital. Like that's why we have all the surveillance cameras now and that technology. So we just need to all talk to one another. We've been hiring litigation assistants. We think with that direct access, we'll stop hearing in court, I've asked for it. I've asked for it 10 times. I've asked for it 5 times. That's too many times to ask. The police should just turn it over.
Okay, and just explain to us, and you can both agree on this, the timeline here. Now, the governor's budget has to be in on, I think, April 1st. But what are we looking at? I mean, that's just the start, and you're talking about legislation.
That's true. And I will also say, like, this took years to create. I didn't say this, the statute, right? With everybody having input. You have given us more input than the governor has given. So thank you for that this time round. And so this is not a budget topic, but this is complicated. This is really weedsy stuff. The budget's due April 1st. I don't think anyone's expecting it. The houses both do their response budgets. We think that's coming out next week now from what we hear. There's a break that mirrors, thank goodness, because I'm a public school mom, at the public school break that starts on April 14th. So they go out of session if they have a budget. So that's talk about an enforcement deadline. Everybody wants April 14th because they also stop getting paid 2 weeks out. That's their last paycheck. So April 14th is like a pretty ideal date, but back in the days, it could go to September, right? Like Governor Patterson had some really late ones, but I would say probably mid-April. We'll have a shot at wrapping that up and getting back to the regular business where we could talk about discovery, right? With full oversight.
Well, we're just looking at, if we're to pass a resolution, we need to understand what our deadlines are. Peyton and Wendy, do you have anything you want to add or ask? You can shake your heads no, that's okay.
No, I mean, I just want to say that I'm Wendy Brennan. I work for Senator Kruger, and this is of great interest to her. I know that she is doing research on this topic. She certainly talked to DA Bragg about it. I'm pretty certain that she's talked to the defense bar about it. And I don't think she's come to a conclusion yet, but she is definitely, this is an important issue to her.
Thank you.
Thank you. So I'm going to propose that, it feels a little unfair that Andy's not here now. And this is clearly a complicated topic.
Yeah.
That the committee members might submit questions, to those who spoke tonight. And if you want, we have the option then to invite them back, because if they respond to us, it has to be in this public forum. Do you feel comfortable with that?
Yeah.
You-
I mean, I agree. It seems like this is like, and the deeper into the weeds you go, like the more there is. I honestly, I feel like a little bit of that our time was wasted tonight, in that it would be more interesting to have heard about the legislature, like the S316.
Yeah, I wanted to know more about that.
Yeah,
That would
and,
impact the
like,
whole.
rather
whole
than
thing.
like Hochul's
Answer.
proposal, but
Yeah.
I know she kind of comes first, just time wise. But yeah, I mean, I have many questions here that we haven't had time, some for one group, some for the other, some for both. And some for NYPD.
Yeah.
And are we all comfortable that this is an issue that we do want to continue discussing?
Yeah.
Yes.
Yeah,
Very
very
important.
Okay. So thank you for
Eric's
this enormous
Wait, Eric.
contribution of energy.
Oh, we gotta,
and
gotta
your
help,
help.
yes.
Stu,
So,
if I could just
I'm sorry,
add
Eric.
one thing really quick. I wanted to say, obviously, you know, we are coming from through the lens of the DA's office. We're hoping this does make it into the governor's budget proposal. So we are, in terms of the timeline, looking at, we know a lot of these conversations are going on in March up in Albany. And then I know you mentioned the April 1st deadline. That is something that we would hope to, you know, if we were to have a follow-up conversation, just something that people would have in mind. Obviously, that's not necessarily a deadline on you guys. That's a deadline on us, on our end. But just wanted to put it out there for you guys to think about it. I would absolutely second, if anyone has questions, we're willing to bring Andy back and continue the conversation. And thank you to Amanda and Callie. It's great to meet you guys.
You too, Eric. And we've been tailing Andy, so we'll come if he comes too.
Yeah. Thank you.
Thank you all so much for having us.
Yeah.
And sorry again for the chaos.
Anyone have anything else they want to introduce to this question?
I was just gonna make a comment about it. I think that this issue is one of the most, because I was thinking about it as both groups are going through it. I think this is one of the most difficult and challenging issues that our society faces, which is on one side, you know, law and order is really important. Being able to when somebody commits a crime, being able to hold people accountable is incredibly important. On the other side, I think that one of the greatest fears of people, but being accused of something without due process, the requisite due process, is also a really a foundational part of being an American. So I see both of those. I see this as a really, I just wanted to make a comment. I see this as a really difficult issue that we should put a lot of thought into, because it's important to see it from both those perspectives.
And do it right rather than do it fast.
Yeah, that's that, yeah.
Very good.
Thank you.
Thank you all. We're gonna
Thank
move to our
you.
next and last agenda
you.
topic.
Thanks,
Thank
everyone.
you. Thank you. So, agenda item number 3. I'm glad you all still have a lot of energy. It's district needs and budget requests. Since you're Brendan, I think you're gonna make a slight statement to us, a small statement.
Sure.
Is Brendan okay?
Yes, he's not well today, but
I'm sorry to hear
hopefully
that.
within a couple of days he'll be back.
Thank you for.
All right, so I will talk to you about the statement of district needs, but a segment of it that perhaps you guys don't often engage with. Everyone is aware that each year CB6 submits a statement of district and community needs to the city. We're required to do that by the charter, section 2800 D10, if you want to go look it up. You're familiar perhaps with the budget requests aspect of this report, and it is a report. But there is actually a narrative portion that goes along with it as well. I'm going to share my screen and show you where you can find this report. But it's like an almost 50-page report, and the city puts it out. If you want to look for it, you can go to the Budget and Governmental Affairs Committee and find it. It's always the latest version is always going to be linked here. And once it loads, you will see that it's a proper report, and it's got policy areas that don't necessarily align with the way the committees are structured here. But there are almost 50 pages of stuff here in various policy areas. And the issue is that while the board has been doing great work in trying to reform and innovate in its budget requests, it hasn't really been looking at the narrative portion, and some of this stuff has become stale. And so essentially, the committees need to look at these and they need to update what needs to be updated, essentially. For your particular committee, there is a policy area, public safety and emergency services. But there is also core infrastructure, city services, and resiliency. Now, under city services, there's sanitation elements that would be relevant to this committee. Obviously, lots of the other stuff probably not, but other committees will intervene there. But if you look at the way these things are set up, and these are mocked up this way because of the portal that we at the office have access to directly to the city, you guys do not have access to. So we just essentially have to recreate it here for you guys. Essentially, it puts 3 tasks to you. Task number 1, the city will ask you to identify within each policy area what is the most important issue in your district relevant to that policy area. One of your colleagues on this committee has already started going in there and putting some stuff in. Do not click on these. It's better to maybe write them down on your own paper and then convene as a committee and discuss. You need to choose one. There's only going to be a selection for one. Highlighted is the one that we currently have and has been there for like years because no one has changed it. And maybe no one wants to change it, but that is the first task. Of these choices, or a write-in, if you don't think your particular topic is listed, you all need to agree on. So that's the first task. However you decide to do that is your own business. Task 2, once you decide which is the most important issue in this policy area, you need to write about it. We have here the blurb that is already written on the current policy area. You can choose to take that, redo it, completely rewrite it, or just make changes. But once you've chosen your most important policy area, you need to then say a few words about it. And then task 3, there are other things, other sub-issues within this policy area that get more specific that you can opine on if you want to. And then we have the current response from the board here. At the very bottom, we have resources that the city provides. Sometimes they're interesting, sometimes they just seem to be like random websites. And some of them were broken, so I just did not include them there. So make of that what you will. But essentially, for both of the policy areas there, and on, if you want, you can see on the side, you have other policy areas If you think that one of those happens to pertain to you, you can start commenting on those, but essentially, everyone has to agree on one thing to say. And so this report will ultimately become sort of the, you know, the persuasive narrative of what's going on in our district in relation to these policy areas. So, you know, imagine yourself at a hearing or even on a talk show or something, and people ask you these questions. You need to be able to speak intelligently about them. That's
No,
what this is here.
never
I can't
speak
talk.
unless the chair has given us.
That's
permission.
that's an image, that's an image too. This is what this is. Whereas the budget requests are very specific. They're just, you know, a Christmas list essentially. This asks us to think cogently and persuasively about the various elements and issues in our district.
So in the time I've been on the board, I don't remember ever
Yep.
touching this. Is this stale from like 2000?
This is,
Years ago?
some sections have been updated more recently than others. But yes, some of these sections are quite stale. They're that Twinkie box that you've left there for 5 years and
And
maybe
it's still
be
good.
might still be good. As some of these passages here might still be
Yeah.
good, but some might not.
So I'm thinking about this, like the word meta has been occurring to me in a lot of the discussions tonight. And
No
certainly
good can come from that.
No, I think it is good,
It's
right?
medical.
It's like analysis versus synthesis, which, whatever. I feel like I'm wondering what role, like, we can look at our piece of it, and of course we should, and more homework, that's great. But it also seems like budget and governmental affairs should take that kind of overview. You like that better than meta?
Yes.
Okay, and say like, okay, what, you know, kind of what really just like, haven't talked about this in 5 years. Let's just get rid of it. Do you know, are they doing that?
I'm not aware that they are. We have the vice chair of budget here.
No.
And I don't want to impose on them any activities or assignments that they aren't willing to
Can
take
I?
on
But-
themselves.
I mean, it seems to be these things are very topical, right? Budget and government affairs doesn't know about public safety or what we talk about here. So like for us to go through and say, this isn't relevant, or it is, or it seems like the committee should look at it first. And then if there's kind of broader things, then maybe we can address it, but like.
No, that's not
yeah.
really what I mean. What I meant more like, you're saying like they're like even the topic areas have not really been looked at. Like I know Sandy really regularly and like every board chair says, is this the right alignment? Like, is this what our committees should be? And, you know, when I look at this, I have like public safety and environment, public safety, environment and transportation. Like there have been so many kind of iterations. And it seems like maybe that same role would be valuable to say, this doesn't reflect, like the overall thing kind of doesn't reflect, as Jesus said, kind of the organization or the community board's overall approach to addressing issues in our community. And I mean, maybe it's exec that should do it. I don't want to put anything on them either.
But I think,
Do you know
so,
what I'm saying?
I think the vision, this is a template. We cannot change the structure of this.
Right.
Oh.
The policy
This is a
areas-
template for the city.
way the policy areas are grouped is the way the city groups them, and that's the way they have to
Got
stay.
it. I'm sorry, I misunderstood
Yeah,
that.
that's the way they have to stay.
Thank you.
So there, it may be that some committees get to work on only one. More than likely, committees will have to work on multiple, 2 or 3 at least. Because that's the way the city, like, for example, community board issues, the city throws that in with parks, and cultural affairs.
Which says what they really think of
Yes,
us, actually.
so, you know, there's no rhyme or reason for why they do it that way. But I have to agree with Steve in that the committees should look at these
Yeah.
first. Because
No,
they
I
are the
agree.
ones that are hopefully the subject matter experts in their particular domains. But yeah, I mean, essentially, this is going to be, think of this as, if someone were to, if an elected official, or more likely, an agency official who doesn't necessarily know much about Manhattan Community District 6, wanted to come and get up to speed on the various aspects of various policy issues in this district, this would be one place that they could go. And hopefully we will write it in such a way that it actually educates them on the issues that are impacting this district. It can also be a sort of guidepost for, or a map for the work that the committees do. So that they're not just shooting at everything and instead have a logical path that they're following.
Is there
Because
a word
especially with
count?
some committees, some committees have it really easy, and that their agenda is literally handed to them on a
Right.
silver platter. Others need to construct it from whole cloth, and so they need to be careful not to go astray.
Is there a word count on those,
Is there
a word count limitation?
there
on those?
used to be, if there is, it will be mentioned there, but
250?
no, many of these have more than that. They're in the, and I've been hearing that the city planning is looking maybe to do away with
Oh.
character counts. So don't worry about that so much. But there's no need to be prolix unnecessarily. But yeah, you guys can, split up the work how you see fit. As far as the deadlines are concerned, it would be nice to have this before you all break for the summer. That way, any other committees, maybe at that point, if budget wants to take a look at them and maybe see, okay, this doesn't make sense, or this sounds off base, or whatever, or this is not persuasive enough. Then they can, or board leadership wants to do that. But if we're getting this like in late September and you guys are voting on this in
Yeah.
October, by that point it's too late. It more than likely either nothing will go in or whatever you guys say will go in. So ideally, you guys would do this, would sort of wrap it up and decide this is what you want to submit at your June meeting or before.
Can I make a quick comment? Sure. Following up on what you said, I've had several people that are running for office or Murray Hill board, ask specifically or use this as a reference point specifically for how they orient their policy and their thoughts about the community.
Yes. And
Make it
unfortunately, it's a little
right.
old, so hopefully for future years, and this is a public document, anybody can use this, but ostensibly, it's what it's for is for us to educate these agencies that at times can feel a little remote about our district.
Yeah.
So we all have our assignment. Did you want to add anything since it's your realm? You don't have to.
What is the assignment? Clarify that. As in think of what's important and then think through it.
Yeah.
Okay.
So
just
the
because-
assignment is read all of this,
Mhm.
and then task number 1, think of which of these is the most important policy, issue in this policy area. And then, once you all have decided on that, then start drafting
That sounds like a doodle poll.
a little blurb. If you guys, this is the first time we're really engaging all the
Yeah.
committees at once. If you guys want us to do a poll or something, a poll of 7 people, I mean, you all could conceivably pick a different thing. Each is a different thing, so,
No, but
let's
you
see,
see how many votes, maybe a ranked choice kind of thing?
maybe,
Would you be, I'm sorry to put something on your plate, do you think you could just send us all an email with basically the link to this and?
it has been sent by.
Yeah, that was in
It was already
I
sent.
thought it was in the email we got today.
Yeah. I thought it was already sent.
It was sent a couple of times.
What she means is, can you resend it?
Yes, and I seriously do not, but also, just kind of with just an outline, literally 3 sentences of what you just said in terms of what our homework is.
I think our first homework is we all have to agree on one,
Well, the
Yeah.
Priority.
instructions are written in here.
Oh,
right? I
okay.
mean,
Task
before we
one,
do anything
never mind.
else, that's
Never
the
mind.
first thing. Maybe we do that next time.
But
I don't know if we can all agree on any one thing, but yes.
We'll have
let's
some
look.
people.
Well, majority wins.
Which
We can all agree that we don't always agree.
We can do that,
Yeah.
if we can write that in there, that.
No.
He's like, don't-
when I submit something to the city, we need to choose something.
Yeah, I mean, we can just say, pick your top choice and then majority wins and.
Or whatever.
Or you know, pick 1, 2, 3, and I'll rank them and see where we
Yeah, we'll
want.
do a
Yeah.
ranked choice thing.
I always feel those ranked choices for this kind of thing, not for elections, like mayoral elections
Yeah.
work, but this kind of thing works.
I am so happy we have ranked choice for the Democratic primary. Holy moly, otherwise somebody's gonna win with 6%.
I think so too, but if there's no further business, and I do not have a report, is there any old or new business you want to raise?
I have something.
Well,
Yeah,
actually,
you go.
are we really, I thought the other thing was about our budget requests, right? Because I think that's the other thing.
I was giving you the opportunity, I thought that was all part of the same. Go ahead. Yeah, you want us to discuss that
I
now?
mean, isn't that something that we should talk about so that we're,
It is something we want to talk about right now.
I mean, we can have that be for next
I
meeting if you prefer that.
I think so.
Yeah,
That's fine, that works.
I'm cool with that.
Yeah, that's really fine.
Okay.
The only thing for us from budget is that it does get discussed before the summer break because
Mm.
then there's almost no meeting before we have to submit
Right,
a
in
whole budget.
November.
And that's what happens at the end, and then we get these budget requests that are like, what is this? And we're
Right,
trying to make sense of it.
We can meet over this summer.
You guys only do have 2, you know, you're not in a great rush, I could prop them up on the board.
no, to give us a deadline.
Go ahead, Justin.
2 quick comments. Firstly, I promised back in November on a resolution about using the Link NYC boards to do some
Oh, yeah.
soft marketing for, more so public sanitation, or I guess sanitation. I saw Mark Levine's team actually put something up there for, I think, community boards maybe
Yeah,
about
I
a
saw
month ago.
that.
Oh,
So
for-
I don't have it
Have
today.
fun,
But I'd like to, for next month, I'd like to put that on the agenda, because I'm gonna come up with a resolution this month and we can discuss it next month. It's my first point, and the second thing is just a comment, but I just came from the office where we spent like the whole day celebrating International Women's Day, which is this weekend. And I wanted to just express my gratitude to everybody on this board, and the women in our community that we serve.
Oh.
God, you just
Gee,
scored a
Maggie.
lot of points on that.
It's on Saturday, so,
That's very nice.
Okay, so we're looking for a draft resolution for you next month.
yeah.
Any
And,
other,
or just anybody that wants to talk to me about it.
any other old or new business? Do we have a motion to adjourn?
Motion to adjourn.
I will say, Justin, it is a pleasure to work
I'm
with.
sorry, we have a
All of
motion
our
to
wide
adjourn.
I second.
Meeting is adjourned at 20:27. Thank you all.